or something. Women, because they talk so fast, but he does his
He
thing.
beats them home. All right. Is the appellant ready to proceed? All right, you may.
May it please the Court. When the Supreme Court said in Hensley v. Eckerhart that work on unsuccessful claims should be excluded when calculating the lodestar, it clearly meant work on formal legal claims. In the Supreme Court's words, claims for relief, which is the same language used in Rule 8 of the Federal Rules of Civil Procedure. We know this because the Supreme Court explicitly made that distinction in Hensley v. Eckerhart between claims for relief and relief for the claim, just like Rule 8 does in sections B and C. Here, the plaintiffs presented only one legal claim for relief. That claim was for minimum wage under the Fair Labor Standards Act. What they were unsuccessful on, and what we're here today fighting about, is they were not successful in receiving all of the relief that they requested. If the plaintiffs have proven that Perry's willfully violated the act, plaintiffs would have become entitled to damages using a 3-year statute of limitations rather than the default 2-year statute of limitations, a very unique provision found, I think, only in the Fair Labor Standards Act, where we have this, depending on what the proof is, the statute of limitations changes. And that's a burden that the plaintiffs have. Similarly, if Perry's proved their burden, that they acted in good faith, then the district court could have, in its discretion, not awarded liquidated damages, and liquidated damages under the FLSA are simply a doubling of the initial damages. In other words, willfulness and good faith, the things that the plaintiffs lost on, are not claims for relief. They're not formal legal claims. Instead, those things go to the relief sought for the claim. And that's really what this case is about. The difference between a claim for relief, a formal legal claim, not in the everyday vernacular claim for relief, and a request for relief, or the relief sought, the amount of damages that you get for the claim. The district court, in this case, used the everyday meaning of the phrase claim for relief, like a contention for relief, or a request for relief for the claim. The district court interpreted that to be synonymous with a formal legal claim for relief, and then under that basis excluded all time when calculating the lodestar. That was contrary to the Supreme Court's holding in Hensley v. Eckerhart, and that is why the plaintiffs request that this court reverse the district court. First, I want to talk about why that interpretation is right. And let me just say as a little bit of background. This case is here for the second time on appeal for attorney's fees. The reason, in my view, that it's here, and it seems, in my view or my observation anecdotally, that there are more appeals of attorney's fees, seems like, over and over, is because the standard is confusing. And it's confusing for that same reason. Courts routinely use the phrase, they hear the phrase claim for relief without truly reading the Supreme Court's opinion in Hensley and not distinguish between formal legal claims for relief, similar to under Rule 8, and just the everyday use of I request relief for the claim. And that is what I think has generated a lot of problems and confusion in lower courts when calculating attorney's fees. But let me first try to convince you that the Supreme Court said that, and that there is a distinction between a claim for relief and relief for the claim. The Supreme Court explicitly made this distinction over and over again in Hensley. It repeatedly uses the phrase, quote, claims for relief. Page 434 of Hensley, Supreme Court writes, in some cases, a plaintiff may present in one lawsuit distinctly different claims for relief that are based on different facts and legal theories. Again, the next page. In other cases, the plaintiff's claims for relief involve a common core of facts, always based on related legal theories. That's not an accident that they used for relief. They were trying to prevent the confusion that happened in this case about using the everyday vernacular claim for relief and confusing the damages or the relief sought for the claim with the claim, the legal claim, the elements of the cause of action itself. Supreme Court explicitly made this distinction over and over again in Hensley. Page 435, Supreme Court writes that a fee award, quote, should not be reduced simply because plaintiff failed to prevail on every contention raised in the lawsuit. Again, contrasting with a legal claim for relief. Again, and this is a critical distinction on footnote 11 on page 435, because it specifically says that requests for damages are not claims for relief.
I want to make sure I'm understanding your argument, because as I understand it, the case was here before, and it was sent back because this court made a determination that there was a failure to do a lodestar analysis.
Yes, Your Honor.
Is that right?
The first panel said that the first magistrate judge did not clearly articulate what the lodestar was, that he went sort of straight into the Johnson analysis, and because he didn't clearly articulate a lodestar, they reversed.
All right.
When it went back down, it went to a different magistrate judge. That magistrate judge did it differently than the first judge, and instead of assessing the work spent on reasonableness and good faith as a function of success under the Johnson factors, which is, I'm urging the court is the correct way to look at it, the second magistrate judge said, well, that's a claim for relief, and therefore...
And it's the second one you hear about now.
Right, we're here about the second one.
Because I thought I heard you talking about a reduction.
It's a reduction.
This isn't a reduction, is it?
It is, Your Honor.
Reduction from...
It is a reduction from the total potential fee award, because what happens is...
It's less than what you asked for.
Your Honor, the difference is, it's a lot less. The difference is the district judge excluded every single hour.
I guess I'm just trying to, let me make question
Yes.
as direct as I can. He reduced it from what to what? What was there had to be an existing number from which there was a reduction.
The magistrate judge did not say what the total was before he cut all time.
Okay, so when you say reduction, all I'm saying is when you say reduction, conceptually for me, that means there's a number, and then that number gets reduced.
And that's what happened.
Okay, what was the number?
The judge didn't say, but the fee request was for $700,000 roughly. I don't have the number on the tip of my tongue, but it was hundreds of thousands of dollars more. It was a very significant, effective reduction. And I want to answer your question.
You're saying the judge needs to start with your number, and then if you change it, judge, you reduce it.
No, I'm not, Your Honor, I'm not saying that he had to do that. I'm saying he should have followed the right procedure, the right standard for getting to the end result.
All right.
He could have gotten to the same result using a different analysis, and we wouldn't be here. I wouldn't be complaining about it. The issue is the standard used in calculating the lodestar. It's a significant difference. If request for relief means claim, that means every hour spent, every hour gets cut before you even get to the lodestar. If you do it under the second analysis, then you start with it up here, and then we look to see is the amount of time that we're talking about satisfactory in relation to the degree of success obtained, and then you make a reduction. He could have made a percentage reduction and sort of gotten to the same number a different way. We wouldn't be fighting about it. But that's not what happened. And this is I can't emphasize how crucial this issue is, because it comes up a lot. There are lots of statutes, for example, where the amount of damages increases. You get liquidated damages. It comes up in the ADEA. If there's a willful violation, you get liquidated damages. It comes up in USERRA. So it's not just this case, this kind of case. It happens a lot. And in those cases, there's one claim, but if a plaintiff is not successful on getting all of the damages that they sought, then you run the risk of the judges saying, well, that's a claim for relief. You didn't get liquidated damages. And so therefore, instead of making a reduction for the fact that you didn't win everything in the Johnson analysis, we're just going to wholesale cut off every hour when we get to when we're calculating the lodestar. That's the difference. So instead of starting from this number and looking at the degree of success and is this a satisfactory number in light of how successful you were, which the court can do, the court just shoop, it all comes off 100%. And what we're saying is that is contrary to the express language of the Supreme Court. And I think the reason this has happened is no circuit court of appeals has ever squarely addressed the issue that I'm saying is creating all the confusion, which is what is a claim for relief in Hensley? Is it the everyday vernacular claim for relief, or is it the legal claim for relief similar to the language used in Rule 8? And if you look at Hensley, it's very obvious that they mean a legal claim for relief and that damages are not the same. They write in footnote 11 on page 435 of Hensley, quote, nor is it necessarily significant that a prevailing plaintiff did not receive all the relief requested. For example, a plaintiff who failed to recover damages but obtained injunctive relief, or vice versa, may recover a fee award based on all hours reasonably expended if the relief obtained justified that expenditure of attorney time. In other words, they're saying if it's the relief you didn't win on, when you do the lodestar, all of that goes in, and then in the second step, you ask the question about whether that's a reasonable expenditure based on the relief that you got. You still get to decide whether to cut time. It's just, is it 100% when calculating the lodestar? Or do you look at it as a function of success in the Johnson analysis? That's what the Supreme Court said you're supposed to do, but district courts are not doing it because of this confusion. There's not a clearly stated Fifth Circuit opinion saying what I'm saying the Supreme Court said. There's a lot of cases where it's assumed in the Fifth Circuit opinion in Cizan. Everybody assumes it. They don't say it. There is no Fifth Circuit case directly on point, squarely addressing this issue. And if the court did squarely address this issue, it would reduce the litigation over attorney's fees. Because frankly, I can tell you when we went back down, the district judge said, well, I thought I knew how to calculate attorney's fees, but I guess I don't. There is real, sincere confusion over this issue, and I'm saying it's generated by the confusion between the vernacular claim for relief and the legal claim for relief. And it's very clear, the Supreme Court said, legal claim for relief. That's also supported by the rules. Rule 54C says a final judgment should grant the relief to which each party is entitled, even if the party has not demanded that relief in its pleadings. It's supported by the language in Rule 8, which I alluded to earlier. 8A, 2, and 3, a short and plain statement of the claim showing that the pleader is entitled to relief. Claim showing that the pleader is entitled to relief. That's where the Supreme Court got that. And 3, a demand for the relief sought. It's also consistent with the interpretation of that rule in a motion to dismiss when we're asking, did you assert a legal claim for relief properly? Wright-Miller says that the sufficiency of a pleading is tested by Rule 8A2, and the demand for relief is not considered part of the claim for that purpose. It's also an Eighth Circuit case, Dingsy, D-I-N-G-X-I, that says the same thing, where I'm quoting that quote from Wright-Miller, but it's very clear under a Rule 8 analysis. If I filed a lawsuit asking for liquidated damages without an underlying minimum wage claim, I would lose, or I should lose, under a Rule 8 analysis. It's not a claim for relief. It would get dismissed. And the Supreme Court said that if it's not capable of being brought in a separate independent lawsuit, it's not a claim for relief. And you should address your failure to win on that contention in the Johnson analysis not wholesale slash every single hour when calculating the lodestar. And the district court, in this case, the magistrate judge in this case, did not do that. And I'm not saying the magistrate judge is like he's brand new judge, he doesn't know. Everyone is confused because it's not clearly articulated, the distinction that I'm making in this case. This really is a case of first impression, and there's not even cases in other circuits that say it. The Sixth Circuit case that I cited, the West case, says that a request for extra damages, basically, under the FLSA for liquidated and the statute of limitations, that those are related claims as a matter of law. But I'm saying that's wrong too. It's one claim, there's one legal claim for minimum wage with alternative requests for relief that increase the damages for the claim. The Sixth Circuit didn't get it right either. It's an unpublished opinion, but I'm just highlighting that to show the court how crucially important this opinion is and this issue is. This is not, oh boy, another, which most appeals of attorney's fees are, why are we here? It's an amount. We're not talking about the result. We're talking crucially about how we get to the result and what is the standard, and the standard is not explicitly stated or understood by district court judges.
I'm reluctant to ask this question, but it sounds like what you're saying to me is if the magistrate judge applied what you contend is the correct analysis.
I'm quoting the Supreme Court.
If that was applied and yet the judge reached the very same number that we have here now, you'd be fine with that result?
Well, I'm saying, Your Honor, if he came to the exact same number using the correct legal standard, I would not have appealed because it was very difficult to show a court abused its discretion when they applied the correct legal standard. What I'm saying is theoretically, he could have achieved the same number. And I cited a case from another circuit where it was reversed for this reason. It went back to the district judge. The district judge came to the exact same number but didn't say why. And the Circuit Court of Appeals said, well, you could have been right, but you didn't say why, so go back and do it again. So, yes, he could have done that, and we wouldn't be fighting about it, because theoretically it wouldn't be an abuse of discretion to come to the exact same number. But he has to say how he got there. You have to show your work, just like my geometry teacher told me to my chagrin in high school. You have to say how you got there. And that's about the only way district judges get reversed in attorney's fees cases is when they don't show their work.
How is your client injured?
Pardon me, Your Honor?
How is your client injured?
Well, he's injured, Your Honor, because I think if it was done the correct way, the fee award would be hundreds of thousands of dollars more, and the clients, the attorney's fees belong to the clients, Your Honor. And we know that because the first magistrate judge award was a couple $100,000 more than this judge found.
So we have basically an error in the amount we know that as you put forward that this failure translates directly to some very substantial loss.
Yes, it's a couple $100,000 at the very least difference between what the first judge said was reasonable and what the second judge said.
I'm not sure I'm tracking you on exactly what the failure here is, but
Your Honor, the failure is if it's a claim, if work spent on liquidated damages is a claim for relief, the judge can correctly exclude every hour when calculating the lodestar. Here's the fee application for $700,000. Yeah. Well, the error is that's not what the Supreme Court said.
Thank you, counsel. Mr. Schooler.
Yes, Your Honor. May it please the court, I'm Lionel Schooler, the counsel for the appellee. I was going to start with something else, but in light of what I just heard, I need to bring to the court's attention what the U.S. Supreme Court says in Hensley on the very next page after what was just quoted by my opponent. As the court stated in Hensley, if a plaintiff has achieved only partial or limited success, the product of hours reasonably expended on the litigation as a whole, times a reasonable hourly rate, may be excessive. This will be true even where the plaintiff's claims were interrelated, non-frivolous, and raised in good faith. That's on 461 U.S. 436. What I took from my learned colleague's presentation in his briefs and what he just said today was, hey, when it comes to the Fair Labor Standards Act, there's one claim, wages. There are not three claims, base wages, liquidated damages, and willful extension of the statute of limitations. Respectfully, that's just wrong. And frankly, from the history of the case, as you'll see from the record, this is exactly the way the case was pursued, that there were three distinct measures of relief that the plaintiffs wanted. The first time around was in August 2016, after this court rendered a decision in a case that raised a similar issue called Steele versus Leasing Enterprises, which had to do with the legality of the deduction that my client was taking. The Fifth Circuit ruled against. We then issued a statement the following week to the district judge. We lost. We're not going to relitigate this before you, Your Honor. We are standing ready now to pay the wages that are owed to the eligible participants. On the first appeal on the merits that occurred in 2019, which is 19-50391, this court took an appeal from the plaintiff's challenge to the district judge's refusal to award liquidated damages or willful remedies. And this court said, the statement by my client in June of 2016 satisfied the standard that there wasn't going to be any more litigation about the base wages. For whatever happened from then on was only focused on something else. In August 2016, the district judge conducted a status conference. Well, folks, it looks like the Fifth Circuit's resolved the issue. I think it's time to wrap this up. The plaintiff's counsel vociferously protested, saying, hey, you know, we really haven't had a chance to litigate liquidated damages and willfulness. We deserve that opportunity. And this was in the face of the other court in the Steele case, the federal court in Houston, having ruled that there was no liquidated damages and there was no willfulness, and affirmed the district judge's ruling there. On the basis of their protest, the district judge here said, okay, I'm going to give you a year, actually 14 months, go do discovery, limited discovery, and we'll have a trial. In May of 2017, the plaintiffs filed a motion for summary judgment. They did not say a word about the base wages. They did not say a word about the base wages having resolved the issue of liquidated damages and willfulness. They said, here is the evidence we rely upon. We are entitled to a separate judgment that there should be liquidated damages because the defendant acted in bad faith, and there should be a finding of willfulness. The district judge denied the motion. They filed a motion to reconsider. The district judge denied that in July of 2017. In the July ruling, the judge said, you know, I've read what the Fifth Circuit said in Steele about liquidated damages and willfulness on these exact same facts. And what they said there was compelling. But if you want a trial, I'll give you a trial. They filed a trial brief in October 2017, right before the trial, the plaintiffs did not say a word about how the decision on base wages foretold the result on liquidated damages and willfulness. They actually had a trial specifically focused upon liquidated damages and willfulness. About 9 months later, the judge issued his memorandum of opinion upholding the decision that there was no willfulness, there was no bad faith. The case proceeded then to a resolution. The judgment was entered in late February, early March of 2019. My client paid the base wages the next day. About 3 weeks later, the plaintiffs filed their appeal, 19-50391 that I referred to earlier. And that panel said, we agree with what the district judge said. It was really foretold in the earlier appeal. No liquidated damages, no willfulness findings. Then we come to, and in the merits appeal, they didn't say, well, gee, we won on the base wage. We ipso facto, we went on liquidated damages and willfulness. In the second appeal, which was our appeal of the first magistrate judge's ruling on attorney's fees that got vacated by this court, they did not say a word about how they were guaranteed all their attorney's fees because they had prevailed on the base wage claim. They tried to uphold what the magistrate judge had done there by saying there wasn't any clear error in how he analyzed the situation. He actually did a lodestar. This court disagreed. This court said, no, we don't find any mention of a lodestar whatsoever. It is only now that they are unhappy with the result that they come to you with what appears to me to be a theory that the willfulness, the bad faith, the liquidated damages, and the base wages are conjoined at the hip, that once you decide one, you decide them all, and when you're going to assess attorney's fees, you follow one formula. First, lodestar, and then independently of that, a consideration of the Johnson factors. Well, Judge Graves, in the Black v. Settlepoo case, you said it's not unusual for a district judge to take consideration of some of the Johnson factors when deciding what is a reasonable attorney's fee. And Judge Higginbotham, you agreed with that in Hobbs v. Evo. It's natural when you think about the result obtained and who prevailed. It's not a clear, bright line between the Hensley standard on the lodestar and the consideration of the Johnson factors. In this particular case, the magistrate judge here announced in his ruling, or his report, I should say, that he went over 3,000 time entries line by line and made a determination that 1,865 of them were legitimate. He specifically said, I'm not going to allow fees for the work that was done after the middle of 2016 on liquidated damages and willfulness because they didn't win. It isn't reasonable for somebody to do that. And so to answer the question you posed earlier, Judge Graves, the initial award that was sought was something in the neighborhood of $745,000 plus another $50,000 in expenses. The magistrate judge says, no, I've come to 1,860 hours that are legitimate. There's no dispute over the rate. And so that gives me this number. Now I'm going to swing over to Johnson on top of what I've thought about the merits here, and I'm going to find that there is a 10% reduction over and above what I just told you because I don't like the way they kept their time. There are a lot of vague entries in here. They charged for work on other cases. They charged for travel time and did some other things that the magistrate judge felt were unrecoverable. And as a result, his ultimate number was about $412,000 for the lead counsel, and for my colleague over here was approximately $20,000. And the magistrate judge specifically said, as to Mr. Sturm's time, I am specifically excluding the time he spent prior to the date that the judge issued his ruling upholding the fact that there was no liquidated damages and no willfulness. Because we told the district court that Mr. Sturm stepped forward after that ruling and worked with us to figure out who's eligible for recovery. Let's get the people paid who are entitled to be paid. Another thing that the magistrate judge commented on was that not only was the fee application suspect, but now the plaintiffs were interjecting the concept that they should be entitled to an award for inflation, meaning the passage of time. This case was filed in August 2014. We're now in year 9. However, the magistrate judge said, well, first of all, you wanted to stop the case until the Fifth Circuit issued its ruling in Steele. Then you wanted to stop for another year so you could litigate liquidated damages and willfulness. And then you wanted to challenge that on appeal, so I'm not giving you any upgrade here because there's inflation. I've heard it said today, I think I heard it said, that this holding might affect other cases. Respectfully, it's pretty plain vanilla. If you want to get attorney's fees, they have to be reasonable. You have to use good billing judgment, which the magistrate judge questioned, and you have to show that you prevail. And there's absolutely no reason why these people should get $750,000 in part for litigating on claims that they did not prevail. I would also point out, it's a technical point, but I would also point out that in filing their objection to what the magistrate judge did, the plaintiffs did not object to the findings, the factual findings made by the magistrate judge. And so in that sense, that's not a matter they can even bring to this court's attention based on the instructions that the district court followed based on the impact of failing to file that complaint. As I understand it now, their whole basis for their claim is you got to lump all these together, willfulness, bad faith, wages, and you look at them all as a group, and you've got to have a clear line between Hensley and Johnson, and you go through the Hensley exercise first, and if something spills over there, that's not the way it's supposed to work. You've got to keep a bright line between those. That's not how the law works. It's not what the Supreme Court contemplated. Therefore, we urge the court to affirm the result of the district court. And I'll answer any other questions that you might have.
Thank you, counsel. Rebuttal.
My friend on the other side says that the plaintiffs only now complain. That's not supported by the record. We're only now complaining because the first judge did it correctly. The first magistrate judge discounted time spent on the issues of good faith and reasonableness in the second step, in the Johnson analysis, which we say is the correct way to do it. He didn't wholesale cut all of us. It was not an issue in the first appeal, so that's why it's being raised now for the first time. The legal mistake happened only with the second judge, from which we are now appealing. My friend also said, when he made a distinction or attempted to make a distinction about the language in Hensley, and he quoted a part of Hensley where he said, where there is only partial or limited success, the result of the lodestar may be excessive. That proves my point. The Supreme Court in that sentence is talking about the second step. They're saying you should include all of the time if it's only one claim, but then if that's too high, if there's only partial or limited success, the result may be excessive, then you go to the Johnson analysis and examine the result that you got in the lodestar as a function of degree of success. What he quoted to you actually supports my case. But the language he quoted to you from Hensley is the second step, which is what the Supreme Court says to do. That's not what happened here. I mean, there's some other things that he said that are not issues on the appeal, things that happened in the district court that we have not raised in our brief, so I'm not going to address those. There's no such thing as a base wage under the FLSA. You'll never find those words in the FLSA. There's only one claim, and there's no dispute that that's true. They've never countered that with any citation to any statute. Let me leave with this. There is a Supreme Court case that says that if there's only one claim, you include here in the lodestar, and then you take away in the Johnson analysis. If they'd done that, we wouldn't be here. The question is, what is a legal claim? Does a request for liquidated damages under any statute, the ADEA, USERRA, the FLSA, or is that a claim for relief? The Supreme Court said over and over, and specifically in footnote 11, that it is not. A Fifth Circuit case, the one that they also cite, Fessler, v. Porcelian, I think I've said it right, and that's a 2022 case. That case says the same thing. That case says that they cite Hensley for the proposition that no fee may be awarded for work on unrelated claims that are unsuccessful, but then says, quote, The unsuccessful ones must be treated as if they had been raised in separate lawsuits, an implicit acknowledgement that the standard is an independent claim for relief that could have been capable of being asserted as a standalone legal claim in another lawsuit. If you lose on that claim, it all goes away. The court should exclude all of that in the calculation of the lodestar. That's what a court should do. But if it's not a separate legal claim capable of being raised in a separate lawsuit, then you include it, and then you examine and come down, if necessary, in the Johnson factors. So we have a Supreme Court case directly on point that it addresses this exact issue. It says it in footnote 11, what a claim for liquidated damages and an extension of the statute of limitations are clearly relief requested for the claim. The Supreme Court said if it's relief that you didn't win on, it's included in the calculation of the lodestar, and you address it in the Johnson factors. My friend on the other side quoted the exact part of the opinion where they say that. There is no case, circuit court of opinion anywhere, that says what this district court did is correct. And that's the problem. The district court didn't get it wrong because the district court didn't research it. It's confusing by saying claim for relief. A claim for relief, the Supreme Court said, is not the same thing as a relief for the claim. So I'm going to leave your honors with that, and I really urge you to consider that this is an extremely important issue, not just in this case, because we're talking about not the amount or the result, but how we got there. Thank you.
All right, thank you, counsel. Court will take this matter under advisement. That concludes the cases that are on today's oral argument